Hey, it's Charles here from RCSA. I'm in Brisbane today, and I just wanted to bring you up to speed in where the developments are occurring around the Skene and Workpac decision. So many of you will know that last week the full bench of the Federal Court handed down a decision in relation to Skene and Workpac. And based on our assessment of that decision, determined that despite the fact that a on-hire casual employee was defined as casual under an enterprise agreement, the Fair Work Act actually afforded that worker an entitlement to annual leave in addition to a casually loaded rate. That, of course, is quite concerning. The facts around the decision are interesting in the sense that he was certainly an ongoing on-hire casual employee, but certainly not so different as to not raise some concern about whether it could extend to other on-hire casual employees, especially those that are assigned on one assignment with one client doing one piece of work for a period of 12, 18 months or more. So we've been out there, we've been having discussions with politicians in Canberra, we've been having discussions with other business groups, because it's also important to understand that this decision will impact any longer term casual employee, not just on hire casual employees. So many of our members are asking us, what do we need to do now? I think the simple reality is that we need to wait and we need to continue to respect the fact that it takes time to actually understand the true potential implications of a decision of this nature. Certainly there are some things that can be done to try and mitigate your risk, and one of those would be to ensure that you have well-drafted contracts of employment that very clearly articulate the casual nature of employment, the fact that the employer receives a loading, in most cases 25%, that is payable in lieu of annual leave, personal leave and other permanent employment entitlements. The other thing is, of course, is to not overpromise in terms of the ongoing nature of the work, especially when it's casual employment. Even though this may be difficult because the employee wants advance commitments to ongoing work, that does create some concerns in the eyes of the law. We're going to be continuing to lobby the government to try and get some change to legislation, but that is difficult at the moment given some of the issues with the Senate and, of course, some of the other issues that are occurring at a federal political level. We're also supporting our member Workpac where we can to see and determine whether they will appeal the decision to the High Court. So we're also going to be running a webinar very shortly which will give you an outline of the different options that you have. We're working with the Australian Chamber of Commerce and Industry and all of their other member groups, given the fact that this impacts all employers of casual employees on a long term, to really try and get an awareness around there as to the implications for business confidence. So ultimately what I would like you to do is not to panic, to sit and wait for information to be provided through to you that will give you a better and more considered understanding as to how you will be able to make sensible business decisions moving forward. So within the next 2 weeks, we'll be providing you with a webinar with an update in terms of where we go next, and we'll also be providing you with written advice and also providing you with information that you can pass on to your clients as well. So if anybody has any particular concerns, then they are very welcome to, of course, contact the Workforce Info line, and you can get those details from our website, rcsa.com.au. That is manned by FCB, workplace lawyers who understand this area very well and are advising us. You may also send an email through to info@rcsa.com.au. Bottom line here is we have your backs covered. We're working hard to make sure that we can get sensible outcomes from an interesting and difficult scenario created by vagaries within the Fair Work Act. So we look forward to continue to update you on these important matters, and please don't, of course, be concerned or certainly don't be afraid of reaching out to us to engage. We have a workplace relations working group that is furiously looking at what is the best outcome for our members, and will continue to fight and lead in the world of work. Thank you.